Dave Kopel of the Independence Institute, who joins us on the program right now. Dave, how are you, sir?
I'm doing good. How about you?
I am excellent. I appreciate your time today. And we've been talking about the arguments held last week in the Fourth Circuit Court of Appeals in Richmond, challenging Maryland's gun ban and magazine ban. The oral arguments are available for folks to listen to online. How do you think the oral arguments went, Dave?
I think reasonably well. People pay a lot of attention to oral argument because it's sort of, from the media's point of view, it's the most exciting thing you can follow, and you've got the questions and answers from the judges to the lawyers. But really, the briefs in a case are far more important. I mean, the oral arguments, the very last stage, and it's a chance for judges to ask questions if they have any, and probe what they see as weaknesses in the written arguments. But it's the written arguments that are the biggest deal. And I think the pro civil rights lawyers did an excellent job in the briefing in this case.
It seems like, based on some of the questions from the judges, certainly that the briefs had been read. The state of Maryland, the attorney for the state of Maryland was asked, for instance, all right, well, how is this any different from the in essence, the D.C. gun law in Heller that was struck down? Are you not, in fact, banning an entire class of firearms? Asked a lot of questions about, could you, under the state of Maryland's reading of the Second Amendment, could they ban semi-automatic handguns? Because you could still, own a revolver. And
right.
Apparently the attorney for the state of Maryland acknowledged that, there's really no functional difference between a revolver and a semi-automatic handgun, but that somehow these guns in particular that the state of Maryland is banning, these are unusually dangerous, the state says.
Yeah, which is I suppose shows the creative energy of the Maryland government lawyers, because the Supreme Court in Heller had explained that traditionally the English common law and the English understanding of their right, the English right to bear arms, excluded, quote, dangerous and unusual weapons. So by an American context, poison gas would be, and anthrax spores would be things that you might say are weapons, but they're not protected by the Second Amendment because they're dangerous and unusual. The Maryland attorneys, the Maryland government attorneys, not really truly representing the people, but representing the unconstitutional law, invented this new category they call dangerously unusual, which it doesn't exist in law so far. And what they're trying to do is, or unusually dangerous, I guess. And here's the problem they have, is it's just undisputable that what they banned are common arms. What Heller said is protected. Arms typically used by law-abiding citizens for lawful purposes. AR-15s alone, that's the most popular rifle in the history of the United States. And that's outlawed. And as well as many other popular arms, and certainly collectively that class of arms is very popular. So once you're indisputably common, well, then you can't possibly be dangerous and unusual. So the Maryland attorneys invent this new category of unusually dangerous. So we'll see if the Fourth Circuit is open to their creative shenanigans.
Yeah. Do they have to define, and have they tried to define, Dave, what it is about these firearms that make them so unusually dangerous? I mean, because the state of Maryland said, we're not banning all semi-automatic rifles. We're just banning these that we have classified as unusually dangerous.
Oh, the usual category of junk and lies that's been coming out of the gun ban lobbies ever since they invented this issue nearly 30 years ago. They're no good for self-defense. Their only purpose is to spray fire from the hip for mass murders, blah, blah, blah. The things that every gun owner who actually knows about guns and has maybe tried out one of these guns with a friend at a shooting range knows to be false.
All right, we don't know when in the Fourth Circuit will rule on this case, but are any of these issues similar to the case that you've been involved in, challenging Colorado's new gun control laws?
Oh, sure. I mean, you get somewhat similar arguments in Colorado over Colorado didn't ban any guns, but they outlawed magazines over 15 rounds. So it's the same kind of thing as we haven't banned everything. There's still things you can use. Granted, they're not the things that you choose to use, and granted that, as we have actually by stipulation in this case, that there are tens of millions of magazines over 15 rounds in law-abiding hands, which would seem to fairly easily get you into the category of commonly owned.
Absolutely. And Dave, I mean, I know that coming up here before long at the NRA annual meetings in Nashville, one of the big parts of the annual meetings is the seminar for attorneys, law students, and is this going to be a topic? I'm sorry. Go ahead.
Civilians can attend this as well.
Absolutely, yes. Now, our continuing legal education credit may just be for our own personal edification, but yes, it is open for non-lawyer types as well. I always have to miss it because I'm always on the air, but I always want to go, and I'm guessing that these are some of the big subjects, both these individual cases and the issues in these cases that are going to be discussed at the seminar this year.
Sure, certainly that's part of it. For example, Steve Hallbrook is one of the speakers, and I haven't seen a copy of his presentation, but he typically talks with a good update on litigation. And as you know, he's been heavily involved in similar cases in New York and Connecticut. And in another one of the excellent speakers there is Masad Ayub, who was an expert witness in our Colorado case and really an outstanding public speaker. And it's a great opportunity to hear him speak live. That'll be a highlight for a lot of folks. And I'd also say for the practicing lawyers, there is a tremendous amount of valuable information for stuff that you might do as a practicing lawyer, not necessarily in a big constitutional case, but, all the needs that clients have every day about firearms trusts, representing an FFL during an ATF audit, a citizen who wants to have his rights restored, all those things where, numerically are by far the largest class of things that would come to a lawyer's attention and hopefully generate a fee where he can provide expert-level services after attending this seminar.
Absolutely. Well, Dave, listen, I really appreciate your time, sir. And any word on the Colorado case itself that you're involved in? What's the next step there in that case? The
Attorney General's brief is due on April 22nd, and then our reply brief will be due in May. And after that, that's the end of pretty much the end of the written phase of the case before the 10th Circuit, and they will schedule an oral argument sometime. They typically don't hear oral arguments in the summer, so, hopefully sometime this fall.
All right. Mr. Dave Kopel, Research Director of the Independence Institute, thank you so much, sir, and look forward to seeing you soon.
Sounds great.